Dear learners, in this lecture, we shall be continuing our discussion on a very important aspect of a partnership law, often which is a subject matter of dispute between and amongst partners. The topic is minors agreement or minors agreement in a partnership, or what is the capacity or legal status of a minor to enter the partnership firm. So, firstly, we shall be discussing as to who is a minor and what is the legal framework governing his contractual capacity. So, generally speaking, a minor is negatively defined as somebody who has not attained the age of majority. The law of majority is contained under Section 3 of the Indian Majority Act. The age of majority is 18 years, or there is a provision related to the ward of the court, which is for 21 years. So in India, the age of majority is generally 18, but this may be extended to 21 years if a guardian is appointed by a court for a minor in order to take care of his interests. A ward of the court refers to a minor for whom a court has appointed a guardian, and as a result, the minor is considered a ward until the age of 21 when they legally reach the age of majority. Now, there is an interplay of law of contract in the legal capacity of a minor to contract. There is Section 10 of the Indian Contract Act related to capacity or competence of the parties to enter into a contract. And we have Section 11, which declares a minor not to be competent to contract. So the interesting thing here is that with regard to the minor's capacity to contract in a partnership firm, this is not determined under the Partnership Act, as it does not define who is a minor. Rather, it is some supporting laws, that is the Indian Majority Act as well as the contract law, which shape the discussion on the minor's capacity to enter into a partnership agreement under the partnership law. So now, looking at the provisions of the Contract Act, we have Section 10 and Section 11, which are relevant for our discussion. So Section 10 talks about who are competent to contract. So according to Section 10, all agreements, they are contracts if they are made by the free consent of parties who are competent to contract. So the word competence here is important with respect to the minors. And then we have Section 11 as to what agreements are contracts. So every person is competent to contract who is of the age of majority. So the age of majority has to be linked to Section 10, use of the word competent, according to the law to which he is subjected to. So according to the contract law, the minors, they are not competent to contract. And because the partnership agreement is also a kind of a contract, a special contract, so therefore this provision of the contract law also creates an inhibition of the minors to become partners in a partnership firm. So there are several legal issues which complicate the issue of minors being admitted as partners in a partnership firm. So major questions which have emerged is whether an agreement with the minor is void or voidable, two very important expressions of contract law. What is the distinction between void or voidable contracts? The primary and most fundamental distinction between the two terms is regarding their enforceability in a court of law. So, a void contract is inherently unenforceable from the moment of its creation. Uh, a void contract lacks the essential elements of a legal contract, making it as if the contract never existed. In contrast, a voidable contract is initially valid or conditionally valid and enforceable. However, it can be voided or cancelled or repudiated, whatever you may call it, by one of the parties involved in the contract if certain specific conditions are met. So, therefore, void is a stronger expression as compared to voidable, because a voidable contract may be elected to be made void. Now, the Indian Contract Act as well as the partnership law do not contain any provisions whether the partnership agreement with a minor is void or voidable, and many of the judgments which were there for a long period of time, they were conflicting of several high courts. So some of the high courts were of the opinion that it is void, while some were of the opinion it is voidable. Now, the clarity on this issue came only after the decision of the Privy Council in the case of Mohri Bibi versus Dharmodas Ghosh, in which it was specifically settled that a minor's contract is void and not voidable. Now we shall be relating this discussion to the minor's agreement under partnership. Now, the baseline provision governing the minor's capacity to enter into a partnership firm is Section 30 of the Indian Partnership Act. The general rule is that a minor is incompetent to contract according to the Indian Contract Act, and so because partnership is also a kind of an agreement between the partners, so therefore he cannot become a full partner. However, the partnership law does create a certain exception to this general rule, which is contained in Section 30 Clause 1. Now, this Section 30 Clause 1 reads as minors admitted to the benefits of the partnership. So, not that minors are being admitted to the partnership as partners, but they are being partially admitted or conditionally admitted. So, we have the word partial and we have the word conditional. Only to the benefits of partnership and not as full-fledged partners. Now, they could be admitted to the benefits of partnership with the consent of all the partners. So, what is required here is again the rule of unanimity, that all the partners should agree to the admission of a partner who is a minor only to certain benefits of a partnership. So, Section 30 Clause 1 reads as a person who is a minor according to the law to which he is subject to may not be a partner in the firm, but with the consent of all the partners for the time being, he may be admitted to the benefits of partnership. So, therefore, this rule under Section 30 Clause 1 partially modifies the general rule which excludes the minors from having an association with the partnership firm as partners. So, there are certain benefits, privileges and rights which Section 30 creates for the minors who are admitted to the benefits of partnership, but because they are not full-fledged partners, so they have certain limited rights as compared to full-fledged partners. So I am going to talk about the 4 rights which are conferred by Section 30. The first is they have a share in the profits of the firm and the property of the firm in accordance with the agreement between the partners. However, the limitation is that a minor cannot participate in the functioning and management of the firm's business, as he or she does not have the legal capacity to bind the firm. So as we know that a full-fledged partner is an agent of the firm, and his actions have the capacity to bind the other partners as well as the partnership firm. But this rule of agency does not apply to a minor because he does not have the competence to contract. So therefore, some of the rights of partners which are available in a partnership law, only some of the rights are applicable to a minor. The second right of a minor is access to accounts of the firm. So a minor has the right to have access to and inspect and copy any of the financial accounts of the firm. However, this is a limited right again, which is restricted to the accounts of the firm, and he has no right in respect of books other than the books of account, as such other books may contain trade secrets, which is a confidential and a privileged information, the access to which can only be had by the full-fledged partners of the firm. The third right is that a minor has the right to sue for share of profits and property of the firm. However, this is conditional upon the minor severing or disassociating his connection with the firm. So at the time or after he intends to sever his connection with the firm, then he can sue some of his other partners for the share of profits and property if he feels that he is being unfairly treated by the other partners and not being given his due according to what was agreed by the partners to give a share in the profits of the business to the minor. The fourth right is that he has an option to become a partner on attaining the age of majority. So again, this is an option. So it is legally open to the minor to become a partner or not to become a partner. However, a limitation is that whatever his rights were in the share of profits, they shall remain the same when he was admitted to the benefits of the partnership to when he elects to become a full-fledged partner on attaining the majority. So the limitation here is that a minor who is admitted to the benefits of the partnership, he does not get the right to renegotiate the terms and conditions after becoming a full-fledged partner. Then we shall be discussing about the liability of a minor who is admitted to the benefits of the partnership firm. This is discussed under Section 30, Clause 3 of the Indian Partnership Act. Now, the rule provides that the minor shall have no personal liability. Further, the nature of his liability would be limited to his share of profits and property of the firm. Now, this is in contrast to the liability of the full-fledged partners to the creditors or the third parties of the partnership firm, because the partners are personally as well as unlimitedly liable to the third parties for any transaction of the firm. However, because minor is not a full-fledged partner, and considering that his age is vulnerable with regard to his capacity of contracting, so therefore this rather disadvantageous situation where the partners are made unlimitedly and personally liable for any unsatisfied debts of the partnership firm, it does not extend to a minor. The second is that while the minor is admitted to the benefits of the partnership and whatever share he has contributed to the partnership, it becomes liable for any acts of the firm. The exception is that if the partner, the exception is that if the minor, on attaining the age of majority, if he elects to become a partner, then his personal liability towards the third parties for the acts of the firm would be personal as well as unlimited, and then it would be operated retrospectively from the time he was admitted to the benefits of partnership. So, for example, if a minor was admitted to the benefits of partnership at the age of 15 years, and at the age of attaining majority, that is 18 years, certain transactions, they were contracted between these 3 years. So from the period between 15 to 18, he will have no personal liability as well as limited liability to his share of contribution in the partnership firm. But on the attainment of majority at the 18 years, his limited liability would be converted into unlimited liability, starting from the period when he was admitted to the benefits of the partnership firm as a minor. Then, what are the requirements for a minor to become a partner? So, the first is that on attaining the age of majority, within a period of 6 months, he should exercise the option of becoming or not becoming a partner. And if he chooses to become a partner, he must give public notice that he has now converted his association from being admitted to the benefits of the partnership to a full-fledged partner. In case he elects to become a full-fledged partner, he becomes a full partner from the original date, meaning thereby the date on which he was admitted to benefits during the age of minority, maybe 17 years, 16 years, 15 years, as may be the case. Then the other effect is that his limited liability becomes his unlimited liability as well as personal for all acts of the firm from the date of his admission, that is retrospective. The third is that when the minor becomes a partner, he shall have the same share of the profits as was when he was admitted to the benefits of the partnership. The third is that if the minor declines to become a partner in the partnership firm, then he ceases his connection with the firm. Then his liability is limited till the date of his public notice, and then because he is severing his connection with the firm, he can sue the other partners for any accounts, for any share in the profits, if they have been unsatisfied or unmet by the other partner. Then we have section 30 clause 6 that deals with the burden of proof. It reads as, where any person has been admitted as a minor to the benefits of partnership in a firm, the burden of proving the fact that such person had no knowledge of such admission until a particular date after the expiry of 6 months of his attaining majority shall lie on the persons asserting that fact. So, this rule means that the burden of proving that he had no knowledge that he was admitted to the benefits of a partnership firm, it lies on the minor. So the minor has to prove that he had no knowledge. The law will presume that he had knowledge of his admitted to the benefits of the partnership firm. Now we are moving towards the closure of this lecture. So in this lecture we have discussed the minor's agreement under the partnership law. So we have discussed what is the legal competence of minors to enter into a contract. Surprisingly, there is no clear-cut provision under the partnership law. So therefore, the competence is to be determined according to the provisions of the Contract Act and also the provision of the Indian Majority Act. Then we discussed what are the rights of minors who are admitted to the benefits of the partnership firm, that there are limited rights as compared to a full-fledged partner. So in that regard, because some of the rights of the minor, they are limited, as well as the liabilities of the minor are also limited, in the sense that the minor is only limitedly liable for his share and not unlimitedly liable. So his personal property, his personal estate remains protected from the creditors of the partnership firm. So in that sense, we can say that a minor is a kind of a quasi-partner, or whose relation with the partnership firm resembles that of a partner, but is not the same as of a partner. So there are some features of a partner, but then there are certain protective laws that protect the minor from unlimited liability. And then lastly, what are the legal requirements that have to be met by a minor in order to become a full-fledged partner when attaining the age of majority. So with this, we conclude this lecture on minor's agreement under the partnership law. Thank you very much.